A very great afternoon, and thank you so much for being part of this conversation today. I'm Andrew Chamagero, and today we are talking about the judiciary. There is a conversation going on about the criminal division stakeholders engagement. Now, today we're going to be discussing something a little bit much more pertinent when it gets to the criminal division. You and I, we usually have cases, but when we go to court, where do you file your case? Do you know what division you should report your case to and for how long? Well, to discuss this and more, with me I have His Worship Jameson Karemani, the Judiciary Public Relations Officer. And with me still I have His Worship Feston Senga, the Deputy Registrar, the Criminal Division. And I have Ms. Wakoli Samali, the Assistant Director of Public Prosecution. And this conversation is entirely about the Criminal Division stakeholders engagement. On Twitter, go on NTV, follow NTV on Twitter, and we can be a part of this conversation. This entire conversation is brought to you by the Judiciary of Uganda. Good to have you, colleagues. Now I work in judiciary. Yes, good to see you, Festo.
Yes, thank you for hosting the criminal division. We're very glad you give us this platform.
It's an honor to be here. Karimani, Karimani needs to find a desk here. I think needs to find a desk here. Because it's always good to have you again, sir.
Thank you very much for hosting us, and good afternoon, our viewers.
Good to have you, Samali.
Thank you very much.
It's an honor to have a woman again when we're talking about gender representation is something very pertinent. I want to start off with you, Your Worship Karimani. The criminal division, it is a conversation most of us don't understand. What cases does it handle? Of what categories, and how wide is this division?
Thank you very much, and once again, good afternoon, viewers. Criminal division is one of the divisions of the High Court. I would like to enlighten to our viewers about the High Court, how it operates. Now, we have two categories of the way the High Court operates. Within Kampala here, we have what we call divisions. When you move outside Kampala, you will find what we call circuits. Now, in Kampala, the divisions are specialized. Each division handles a special type of cases. Criminal division of the High Court handles capital criminal offenses.
Okay.
And these are offenses which originate from Kampala as a district, Ruwero, Nakasongola, Nakaseke, and Wakiso. That one you have to add in Entebbe. Entebbe looks like it's a district of its own.
It keeps disturbing me. It's painful to say that I'm going to another district in Entebbe.
In Entebbe.
It's like a really ginger.
Exactly.
Yes.
So all cases of that nature which are capital criminal offenses which are committed within that area, they are all handled by the criminal division of the High Court. Now we have other divisions which also handle other categories of cases. We have family division. Family division handles cases which relate to the family matters. That one sits in Makindi. We have commercial court. If you want, you can call it a division, but by name we call it commercial court. Yes. And that one handles matters to do with which are commercial in nature. I have supplied things, they have not paid me, but these ones also, we have to categorize the amount of money involved. If that money has to be above 50 million, that's when it will go to the commercial court. That's when it will go to the family division. If it is below, then you go to these other magistrates' courts. Now we have what we call land division. Land division specializes in handling only land
Isn't
matters.
it the busiest?
It is very busy, as you have said.
Yes.
It is the busiest. Now that one sits in 20 towers, second floor. We have a civil division. Civil division handles cases which are civil in nature. Let's say a vehicle has knocked someone and you want compensation from that person. That one is a civil case. It's not falling in the other category, so it goes to civil division. And the civil division is located on first floor of 20 towers. We have anti-corruption division dealing with cases of corruption, which is located in Kororo. We have International Crimes Division dealing with cases of terrorism, which is also located in Kororo. Now we have the Criminal Division we are specifically going to be talking about this afternoon, which handles those capital offenses which are criminal in nature: robbery, murder, rape, defilement. So all those cases are handled in the Criminal Division of the High Court, which sits at State Square. So those are the divisions that we have in Kampala, which handles cases of that nature arising from those areas.
Okay.
We are planning to have a High Court circuit at Luwero, which will take off for Luwero District, Nakaseke, and Nakasongola, and it will be located in Luwero. Now, when we come to a circuit, we cluster districts. Because we cannot have a judge in every district, so we try to cluster districts and give them one area where they can be handled from. And that is what we call a circuit. You find there is one judge or two. Where we can afford, we put two, but most of the circuits have one. So if I can quickly cite those circuits which are outside Kampala, you have Mukono, taking the whole of Mukono, Uyukwe, this other district on the other side, Kayunga. You have Jinja taking the whole of Busoga. You go to Mbale taking the whole of Bugisu. You have Soroti taking the whole of Teso. We are establishing one in Karamoja, which will take the whole of that region. Lira, Rango, Guru, we taking Acholi. We have Arua taking the whole of West Nile. Come to Mbarara, Ankole, the wide Ankole. You go to Kabale, Kigezi, and Chisoro. So those are the circuits outside Kampala.
And they're already operational.
They are already operational, nice. And we keep adding in more circuits as and when we get resources. And of course, we are trying to. If you look at the colonial history, you'll find that High Court was sitting only in Kampala. The judges would just go to visit in those regions, spend there a month, and come back here. But the population was smaller, the cases were few. So as they kept increasing, we had to make sure that we also trickle down. And we want to trickle down more and make sure that we find like 2 districts having one High Court circuit. So that people have circuits here near them, the judges near them. As we bring the other magistrates closer, we also bring the High Court also closer. As we plan also to decentralize the Court of Appeal to bring it down there in the regions. So that is where we are going. So that is the Criminal Division of the High Court, which we are going to talk about this afternoon.
Well, the conversation is big, and that brings me to the conversation a little bit deeper. To you, my worship, and Senga. The division came up with the concept of daily hearings. Take me through this.
Thank you so much, Andrew, and good evening again, viewers. Daily hearings. Maybe what is the background to daily hearings?
Was it the backlog?
No. Well, backlog also comes in play, but it's also the nature of the way High Court has been conducting its criminal cases. Unlike magistrates' courts, and unlike these other courts like the Civil Division, Commercial Division that His Worship has talked about, criminal cases have always been handled in a session manner, under what we call the session system. What is a session system? A session is where a number of cases are cause-listed or programmed to be heard in a particular number of days. Normally, we program to have 40 cases in 40 days. So that one is because of different considerations, including the fact that criminal cases are multi-sectoral. You have different players. You have police, you have the DPP, you have prisons, you have judiciary, of course. You have lawyers under Uganda Law Society, and obviously you have witnesses. So because it involves very many players, unlike say civil matter where you have parties and their lawyers and the court. In criminal matters, you have these different stakeholder institutions and players. So there is a bit of planning that is a logistical planning that is in a system. And because of such considerations, we have been operating under the session system. Now, the session system has challenges. One of them is that the judge's time is not efficiently utilized. Because remember, we are saying we are going to plan 40 cases for 40 days. So in between one session and another, a bit of time is wasted. Now, this is more significantly felt in the criminal division. Because in other, what his worship maybe didn't tell you, is that in circuits, or he hinted at it, but he didn't go deep into it. In circuits, you don't have specialization. So you have a cross-cutting case categories which are being handled by the circuit judge or judges. So a judge in Arua will have criminal cases, land cases, family cases, commercial cases, Katogo. In criminal, in these other divisions, it is specialization.
Specialized, yes.
Now, when you have a session at the criminal division, and you've completed one session, normally you have 2 or 3 sessions in a quarter, which is 2 or 3 sessions in 3 months. So if you have your 2 sessions in 3 months, in between you may lose a month. And now, since judges at the criminal division do not have these other case categories, a lot of their time is not well utilized. So because of that, we are moving away from the session system to having cases on a daily basis. So rather than having 40 cases in a particular identified 40 days, we are now saying every day a judge must hear a case or 2. So that's the program we are piloting. We began, we tested it in from December. Then we tested it again more elaborately between January and March, and then launched the pilot in April. So we are targeting 100 cases per month, and so far so good. Our 5 judges of the division are doing well. We are meeting our targets, and we think it will be a game changer, and we shall see backlog eliminated the division.
I love that. Coming to you, Samali.
Yes, please.
When you hear this is news and it's music to my ears, because me, I deal a lot with Abantu Bawansi, and cases I've always, dragged in one way or the other. But I'm grateful that the judiciary could sit down and, quantify the time of the judges vis-a-vis the cases. What does this mean to you as the DPP office that deals directly with the public?
Thank you so much, and good evening to our dear listeners. As the Office of the Director of Public Prosecutions, our mandate under Article 120 is to handle all criminal cases. So we handle criminal cases in all courts and appear in all courts apart from the court martial. So in the prosecution of criminal cases, we actually also deal with Omuntu Awansi like you. And you'll agree with me that justice delayed is justice denied.
That's true.
When somebody reports their case to police, they expect their case to be heard. Because they need to be heard. And when we go to court, we all go such that we can be heard. So the challenge we've been having is that in between, like His Worship said, as time goes, cases delay to be heard. So when we are talking about the right to be heard, many times people want to look at it on the side of the accused person. That you see the accused has been on remand for long, his case needs to be heard quickly, but we also have other people who may not be in a physical prison, but are in a psychological prison, and those are victims of crime, and they also equally need to be heard. So for us, the daily hearings give us an opportunity to have our cases expedited and to ensure that our victims are able to access justice. Even to those who committed the offenses, they are able to know their fate and know that let me go and serve my sentence and then get their punishments on time. So the daily hearings to us as the Office of the Director of Public Prosecutions is music to our ears, and we have 10 attorneys who have been attending to these hearings, and this is in addition to other engagements and other mechanisms that we have put in which would include the plea bargain, and which would include also the special sessions. And we are hopeful that if this gains ground and it serves the purpose for which it is intended to after the pilot and we assess, I know that it will go a long way in reducing the case backlog. Because when you look at the categories of cases of sexual violence, when it happens today,
the numbers are glaring.
The numbers are increasing, and every other report that we get from police, the numbers keep increasing. But you see, this is an offense that needs to be prosecuted on the go. When you receive a report today and the girl who was defiled is 5 years and the case delays and it is not heard quickly, by the time the case comes to court 5 years or 2 years down the road, the girl will no longer be 5 years. Those who were 15 are 20. Some will have gotten married. Others will have shifted from one place to another. So giving an opportunity of utilizing the time of the judge on a daily gives us an opportunity also of phasing out also those cases and ensuring that they are before the judge and they are handled expeditiously before the victim changes their status. If it's a case of domestic violence, somebody was beaten last night, they need quick solutions from court. And I think this is one of the quick ways we can get such quick remedies for such victims of crime.
Great conversation. Those who are just joining us, wherever you're watching us from, we're discussing the criminal division in the judiciary. This is going to expedite a lot of case hearing. Coming to you, my worship Karimani, let's talk about the case listings. How is this going to be done? Because someone watching on the other end would be like, okay, I've had my case, so now that this is here, there is that bit of excitement we usually have, like the one I had on your platform. I took my friend there. He had a case. I said, "Let's upload the file." I was a little bit excited. Now, when it comes to this, as someone who is listening and watching, is like, I have a case, but we need to understand the case listing. How are we going to go around this?
Now, we need to first understand how a capital offense moves to reach before the judge for it to be heard. Now, according to our law, when a person has committed a capital offense, that person does not directly appear before the judge. They are charged before the magistrate's court first, where the charges are read to them, and the magistrate will tell that person that he or she does not have the powers to actually ask him whether it is true or not. He only has the duty to inform him that you are here because they say you committed this offense. But inquiries might be still ongoing. Now, the inquiries, of course, are done by the police and, of course, being helped by the DPP. So they will carry out inquiries. And once the inquiries are over, depending on whatever time they take, some of them can be a few weeks, others can take a few months. Once they are ready and they say we have gathered all that we want to prove our case before a judge, the person is committed before the magistrate. Committing means all the proceedings before that magistrate have ended, and the person is ready to be tried in the High Court. So the person will now be sent to the High Court for trial. Now, those are the files which will be received by His Worship, who is the registrar there, or those cases which are committed before the magistrates in the areas I mentioned. There are magistrates in all those areas.
That's the difference.
Now, in Kampala here, you can talk of Buganda Road. People are charged there. Nakawa, Makindye, Nabweru. So those people who commit offenses of that nature are charged there, and they are committed from those courts. And the files are remitted to the criminal division of the High Court. Now, once the registrar there receives those files, he starts planning according to the number of cases he has. He will tell you that he has more cases which have spent more than 2 years there now.
That's a lot.
So when he is planning, he must plan for the first in, first out. except that they have to factor in some issues of the elderly, the SGBV cases. They try to make sure that those ones are taken into consideration, the children. Special interest cases there. But the whole idea would be first in, first out. So you just bring in those few cases, the special cases we have mentioned of SGBV, children and elderly. Sometimes there are those cases which are of too much public interest, which you must get out of your way. You know, some of those cases you have seen them, they are really, they are burning.
We are following. We come to courts with cameras.
Yes, you are following the cameras.
You are following every day. So those cases might also take a special consideration. So he plans for those cases in that way. Now, in the new way of doing things, he will be looking at those cases and make sure they are the ones he puts on the list of handling day by day.
Wow, because it's on a day hearing.
Day hearings, but we must look at first in,
yes, first out.
First out, because people, once you are in prison, you say my case should come out tomorrow. You forget there are people you found there.
Yeah,
they should come out at least before you.
Yeah.
So the cause listing takes that kind of form. But I think since I can add.
Yes.
In the past, I'd said I plan. In the past, when we are doing the session system, we found the judiciary was planning alone, more or less. Now, in this new concept of daily hearings, we've created what we call case management teams. We have 5 judges, and each judge has a team attached to them, which includes a representative from police, from the DPP, from prisons, of course, from judiciary, from Uganda Law Society. So this time around, the planning is not by the judiciary alone, because in the past, we plan, and you find you make errors. You cause list cases for a session, you find 5 of them, the prisoner has died, but you don't know.
Oh, yeah.
You find the other cases, maybe you are planning for Kampala. You remember we handled Nakasongora Ruweru. You find maybe at one point, another judge was given a special session in Nakasongora from another area, and maybe you are not yet aware. So now in the new approach, the planning, what we call cause listing, is to be done concurrently by these teams. So the judiciary, the DPP, especially the judiciary, the DPP, and the prisons, because they are the ones who do the actual planning, do the scheduling of cases together concurrently, so that they eliminate these errors. And then if there are also special interest cases like the ones as mentioned, the DPP will most likely be aware of those cases, and prisons better than we will be. Because for us, we are still dealing with the paperwork. But someone in prison is dealing with people. So they know this one is elderly, this one is sickly, this one is disabled. So they help us say, no, this case is of 2020, but the person is very old, or the person is disabled, or this is a breastfeeding mother. So give it priority. So now the new approach is, we don't plan alone, we do it concurrently. So
it's a multi-stakeholder approach.
Actually, when you talk about cause listing, the DPP is the owner of the criminal cases.
I was coming to you, and I wanted you, I wanted you to dig deep, first of all, about the precisions, and thereafter you take us to what we call the non-starter cases, for purposes of understanding the entire sessions. Let's start with the pre-sessions. Are we having them after every quarter? Are we having them monthly, after 2 months?
So now, since the DPP is the owner of criminal cases, we will know which cases I have in my system. I will know those that have been long in the system. So I will have to work with His Worship in terms of cause listing. Because when he cause lists these cases alone, he will cause list cases that I don't have. But I am the prosecutor. I'm the one who files these cases in court. It is the reason why he works now in consultation with the DPP, and we share notes to ensure that the cases he's cause listing, I have the police files with me, I can trace my witnesses, and I have people who are there, and I'm the one to bring to his attention that this is a public interest case. These victims are old, because when we are looking at interest groups, we don't look at interest groups only of accused persons. We also look at interest groups of victims. We also have cases where the victims are very young, 8 years and below. Such cases should be prioritized and handled quickly. We also have cases where victims are very old, 80 years.
Their memory is fading.
Yes, their memory is fading, but you find a victim of 80 years on and she was raped. So for such cases, they have to be handled quickly before she dies. So those are cases we look at and we prioritize. Some of persons of disabilities, also those cases also have to be cause listed quickly, and then they are cleared out of the system. So before we handle any session, usually we will sit with the judicial officer, his worship, and then agree on how the cases will be, one, fixed for the hearing, and two, how the hearings will go on, because the witnesses are my responsibility, the exhibits are with us, and the rest of the evidence. So we sit and agree on how many cases can be fixed per day, and how many am I able to prosecute comfortably, and then we are able to do that. Then after that, you can do a review after a month, I think now, and then a quarter, and then you can take on other cases.
Wow.
Yes.
The process seems to be multi-sectoral aligned, given that there are other players, the police is in there, the prisons is in there. I found one prisoner who was released, and he had no transport back home. He was walking on the road from Chitaga. I told him,
Others actually don't leave prison. He's one who was stuck, and they also had to look for where to put him. I think they eventually got some NGO which assisted.
You can imagine. Yeah.
It's a topic for another day.
That is a great conversation. Let's talk about the non-starter cases now.
So when we talk about cases, I'll give you an example of cases of defilement, cases of rape, cases, even cases of murder. There are cases that happen today, and give it time, the status changes. Some victims, like, you must be aware that as a country we don't have a witness protection law. If it is an offense of defilement by a father on their own daughter, you'll find that the whole family will be hostile to the child, who is the key witness. Or they will be hostile to the mother, because she is the one who reported the case to police, and therefore is responsible for their son being in custody. So the whole family can either gag up on the mother or on the child.
Victim.
Now, once you have such scenarios and we don't have clear means of protection, they will not come to court to testify for fear of retaliation. And then also the other thing is, now the child will say, they will say that she is the one who imprisoned her own father. So focus now is had more on the accused person and his welfare, without considering the victim and the welfare. So such children or such victims, most likely they will fear to come to court. So where I am unable to trace witnesses, then it becomes a challenge. That becomes a non-starter case. And then we also have other cases of where the case is cause listed, it is fixed for hearing. You look at the evidence and you find that most of your key witnesses have either died or they can't be traced with ease. Those are non-starter cases. So for those cases, the Director of Public Prosecutions under Article 120, the law gives her the mandate to withdraw such cases. Sometimes later in the future we find those victims and those witnesses, and we are able to re-register those cases in court, and they are able to be prosecuted and concluded. However, where we are unable to get witnesses, or where we are unable to trace them with ease. And you see the challenge, problems came in with COVID. witnesses tended to relocate back to the villages.
Yeah.
And when police is recording statements, sometimes the information they include may not be enough for me to trace the witnesses at the time of the hearings. And also the criminal division where we sit, the Kampala population is a migrant population. This month somebody is living in Makindye. When the landlord increases rent, they are shifting and going to Kabalagala. So now when the police is recording at the time of registering the case, they will record resident of Makindye. At the time of hearing, the person has had 3 LCs. So the time of tracing for the witnesses and then also ensuring that I trace them, and then the particulars availed to us by police sometimes are very limited, and then you may say, instead of pushing this case to court, the DPP can withdraw, and then after that we can reinstate when we are able to locate our witnesses. So those are the ones maybe you can consider non-starter. Yes.
I love the examples. My worship Karimani, with all this, I'm looking at the logistics. How easy is this going to be for the judiciary? Now that you speak for the judiciary and all this, we needed this like 10 years ago to expedite the conversation around the cases and access to justice. But logistically, is it something that we can take on as the judiciary?
Thank you very much. Of course, it is a costly venture, but these are our people. We have got to look for the money,
of course,
and ensure that we try them. Those who are innocent have to be set free, and those who are found guilty will start serving their sentences. So, a criminal case is not it's not cheap, because when you compare with the other cases we are talking about, the civil case is between 2 people. Engaging a lawyer is an option in a civil case, but in a criminal offense we are talking about, which is capital in nature, by the constitution, the accused must be represented by a lawyer, either of his choice or a lawyer put there by the state. So that's when we have to come in with what we call the state briefs. State briefs mean you are going to hire a lawyer to represent the accused person in order to fulfill the constitutional requirement. So a lawyer whom you are putting there,
you have to pay.
You have to pay. We have legal aid of Uganda Law Society. We have justice centers, but they have limitations because they are still very few. The lawyers are not many enough. The government has been coming up with a law about legal aid provision, which has not yet gone through. So at the moment we have a fallback of state briefs. So every criminal case you have been hearing about, of day-to-day hearing, there must be a lawyer also in that case.
Catered for by
the state.
That's heavy.
The witnesses, because like she has said, they would have located. Talk of the police officers who are investigating these cases. He was at CPS. He was at CPS at the time he investigated this case. He's the one who did everything. But by the time you hear the case after 2 years, he's in Kotido.
Actually, one came from Kotido yesterday.
He has been transferred to Kotido.
Yesterday on Monday.
So you fix the case and say, we want you as a witness. He's in Kotido. So how do you expect him to? You must provide transport, and you must accommodate him while he's back in Kampala for that case. So that is money. You come to the assessors. We have assessors in our system where they must sit with the judge and give their opinion. And these assessors, you can also qualify to be an assessor.
Oh, I should be invited to one of those.
They are lay people.
They are lay people
who
listen. They listen and say, I think this is my view.
Oh, and that's registered.
Yes.
Nice.
I advise the judge to, this person is innocent, let him go.
Oh, the other witness is honest, the other one is
this one is not. So they are there, and these are ordinary people. So you engage them, then you must facilitate them. So that is a cost. So when you add up all those costs I'm talking about, you find
Logistics
that a case,
is heavy.
I think the last cost we had, a case was around, one criminal case was around 1 million.
It is now conservatively estimated to cost 1.5 million.
Keyword conservatively.
One case.
Conservatively, one case cost 1.5 million. In the criminal division, we have approximately 1,800 cases.
Whoa.
So you can do the mathematics.
You can see how much money would be required to handle those cases. So when you add up all that, you find that to handle a criminal case, you need some money.
Yes, you really need.
And that is one of the constraints we have been having, why the cases cannot move in time, because we must plan and have the money to pay those people.
To facilitate all this.
To facilitate all this.
That is heavy. My worship in Senga, let's talk about the plea beginning.
Yes.
What is it beginning?
Well, before I go to plea bargaining, let me talk briefly about the
Logistics.
logistics. We also have, get partners who support us.
Yeah.
In the past, I've been getting support from JELOS. JELOS has now shifted its code at governing. The umbrella group which has brought to all the law enforcement agencies in the country. It used to be called JELOS, I think now they've shifted.
Governance and security.
Governance and security, yes. So they've been supporting us. We have organizations like IDLO, UN Women, who once in a while chip in and they give us support, for which we are very grateful. But otherwise, it's quite expensive. Turning about plea bargain is a mechanism. It's one of the about 3 mechanisms introduced by the judiciary in the recent past. We have plea bargain for criminal cases. We have mediation for civil cases. And small claims procedure for small cases, cases below 10 million and below, where they are fast-tracked. So plea bargain is where we allow the victim and the accused, with their respective lawyers. The victim will be represented by the DPP. The accused will have a lawyer, either if they can afford, or one engaged by us, by government through the judiciary. So this is where they meet and agree. Where someone, in his heart, he believes, he admits, and he wants to come clean, and atone and seek for forgiveness for his wrongs. So we give them an opportunity to come together, and they themselves agree on what would be the appropriate punishment for this person. Then when they come and agree, then court will step in and see if the punishment is appropriate. When court is agreeable, then that case is concluded at that level. So it allows a lot of participation by the stakeholders. It is very participatory because everyone now participates in seeking for justice. Secondly, it's very cost effective in terms of the logistics I've talked about, because you don't need now to call witnesses, you don't need to go through a lengthy trial which will take days, so you cut on all those costs. Finally, it is a cost cutting in terms of time. Because now, if you go through a case, an average criminal trial will have maybe 5 witnesses. So, but if you do plea bargain, you will do it in one day. Between Monday and Wednesday, we camped at Nakasungura prison, and we finished approximately 80 cases.
Wow.
You can't do that in a trial.
You can't.
In 3 days,
you have to listen.
in 3 days, if you are lucky, you'll complete one case.
Wow.
So it's one of the innovations we have to fast track and also make justice involving.
Now, in this new dimension with the stakeholders in the criminal division engagement, how are you going to promote this in tandem with the 5-team, the 5 teams model you already shared? How are we going to promote the plea bargaining?
You know, we have been having engagements, stakeholder engagements like the one we are having today. And again, I want to appreciate your time in TV. So we have been having stakeholder engagements. But we are going to have a bigger event, what we call Court Open Day. Court Open, that's when we open our doors to the public.
I've attended one.
You've attended one, yes. So we open our doors, and our stakeholders also come there, and we even actually have stalls where we display our tools. So we are planning one to be hosted by the Honorable the Chief Justice at High Court headquarters. So what it was supposed to be by tomorrow, but because of his very busy schedule, it couldn't be possible to hold it tomorrow, so he's going to give us another date. But we engage the stakeholder, the public through these kinds of, through the media and then through fora like the court open day.
Okay.
Actually, on those court open days, we give an opportunity to the public because we serve them.
Yeah.
We don't know whether we are serving them well or we are not.
I've attended one, and it was very close here at, next to the Uganda Railway.
Yes.
I think that was like 3 years ago now,
Yes.
because we had 2 to COVID-19.
Yes.
Yeah.
I attended just to understand the depth of the entire conversation, how the lawyers were behaving, the pleaders, and people really brought cases.
Yes.
Yeah.
And you could see there was service beyond money. You could see lawyers were being moved. Where did you take this case? Do you have this file? Do you have this?
And then we follow.
And
I think what you are referring to is what we would call a legal camp.
Maybe.
I think so. Where the lawyers go out and they give free service to the people, advice, and then guide them. But what we are talking about here is we shall have the judicial officers, state attorneys, we have lawyers, we are all gathered in one place, and the public.
Yeah.
Now, we give the public an opportunity to tell us, you in this place, you do this, but you are not serving us well. We would have expected you to do A, B, C, D.
Good feedback timing.
Feedback timing.
Yeah.
If there is anyone who has any issue with any judicial officer, even side sit and says, I came to this court, I brought ABCD, but this is what happened to me.
Wow. You should put Kalango for
So-
people
People come and raise issues, and then we are able to respond to their issues. Those which we cannot, we take them on and investigate them further and see how we can deal with them.
Wow.
Yes.
Samali, now
Yes, please.
let's come to the plea day of guilt. Most of us, you can only give more attention to judicial issues when you have a case in court. As Ugandans, we usually want to finish our own ways, but time and again we need to go to the courts of law.
Yes.
Break it down for a layman to understand the plea day of guilt and how does it run around?
Okay. Before I go to the plea day, I also wanted to say something about plea bargaining.
Please.
Now, plea bargaining will take normally 3 forms. We have where the accused believes in his heart that he committed the offense. He wants to plead guilty.
Okay.
So that's a plea. So they will plead on that, and then we talk about the sentence. Then there are also scenarios where he will say, but we look at the evidence, and then you're like, instead of the murder, I think from the way this offense was committed, we could consider charging this person with a lesser offense. So we negotiate a lesser offense, you plead to the lesser offense, and you're given a punishment there and then. And then also there are scenarios where we will agree also on the facts, where the facts are presented, we negotiate, and then the sentence is also given. Then we have a mix. So we have a mix of, there are certain scenarios where we can have a mix of a sentence, and then we also have a mix of a charge, the mixed bargain.
So it's a win-win on both ends.
Yes, that it is a win-win on both sides. But most importantly is that when we started this, we were focusing largely on clearing case backlog in court. But as time goes on, we have all embraced plea bargaining as one of the quickest means of disposing of cases, like His Worship has said. But to me as a prosecutor, it gives my victims an opportunity not to be stressed by relaying the same story 2 years or 3 years down the road, because I will not require them to testify. So the trauma they would go through in a full trial
And
of narrating again what happened to them in the face of people who are strangers, in a plea bargain they will not have to. They will come to court, and then they will only give me their views as a victim. This is what I would want to be done to such a perpetrator, and then I take their victims, I take their views into consideration. So we are now also having a focus not only on clearing backlog, but also having a victim-centered focus in handling these cases. So if you see that in most of the camps now that we are doing of plea bargain, you'll find the inmates are there, but then also we'll have a special tent for the victims who will come and also express their views, such that whatever you agree on as a prosecutor and as the defense lawyer, the victim also feels that justice has been done.
There is inclusion.
Yes, because the lawyer of the defense will consult the accused person. Then we'll have the victim also who will also work in consultation with the prosecutor. And we are grateful to UN Women because they supported ODPP in coming up with prosecutor plea bargain guidelines with the focus of having a victim-centered approach when you're handling cases of plea bargain. At all stages, ensure that the victim is notified, the victim is involved. So when we are handling a plea bargain, the stakeholders he's talking about, they are actually all present. So the case is concluded, but everybody leaves when they are satisfied that justice has been done.
So that means now, in a day you can do like 80 cases?
Yes. So now when you talk about the plea process or a plea,
the plea of guilt.
Yes. So when an accused person comes and they accept that the offense has been committed, and they accept that, and we see them every day, you cover them on your story. You find the person from the village, they are admitting, they come to police, they are admitting. So such people should not stay on remand for long. They should be presented to court. We hear their cases and dispose them all. So when they come to court and they are accepting that they committed the offense, usually court will read the charge to the accused person. So they will tell them on such and such a day, you ABCD, it is alleged that on this day you committed this offense, and the particulars are that on this day you went to the home of this, or if I'm to use a case of defilement, you being the father of this girl who is aged 2 years, you performed a sexual act on this girl, and then they will ask you about what you think about the views. Is it true or not? He will tell you, it is true, I did it, then court will record. Then after that, then the prosecution will be asked to give the facts. So in the facts, you're giving details of how this offense was committed, but in the facts, you're relaying the key ingredients that have to be proved. So you give the facts that actually this man is the father to this girl. He produced this girl from this woman, and they are married and living together on such and such a day. But these cases are there. There is one. Yes.
They're totally against our culture, our religious beliefs. I don't know what's
going on. There is one of those cases I handled where the father defiled his own 8-month child, and the reason he gave in his statement was that the mother usually leaves very early in the morning to go to the garden. So what do you want me to do?
Really?
Now, yes, so for such cases we should handle them quickly before the girl grows or something like that. So when I have finished giving the facts, then the court will ask this man also of whether he has understood the facts. So after he says he has understood, then they will ask him whether he agrees that the facts are true. Once he agrees that the facts are true, then the court will go ahead and convict him. So after they have convicted him, then we'll go into submissions. He may plead to court. He will tell court, you see, I'm a first-time offender, I have children, have mercy on me, give me a lenient sentence.
You know, I can't be a judge right now because such a case, and you're saying you're a first-time offender on your daughter?
Yes.
And you have children.
And you have children. Yes, and then for me as a prosecutor, my job will be, in as much as you're a first-time offender, you're not a good father. We can't release you to go go back to other children and such that you also defile them and offend them. And besides that, you're not setting a good example. And apart from that, this is maybe your first time to commit, but we also have very many cases of this category in this, which means that there is a lot of impunity. So we need to send out a message to the community that these offenses cannot occur and you get away with it. So then I base on that, and I also ask for a harsh sentence or a sentence that fits the means of justice. Then the court can go ahead and give a befitting sentence.
My worship, Karimani, I really feel for you people now. and I love that you're going through these processes. And my dear viewers, if you're watching this, and from the district level or from the villages where you actually reside, these are conversations we must have. They're uncomfortable, but we must learn how these processes go through. In this entire conversation, my worship, Karimani, the police report of 2021 indicated that there was an increase in sexual-related offenses, and it indicated 17,533 cases of domestic violence in 2021. The big number of cases in one field alone. For the matter of all this, has the judiciary dedicated a sexually gender-based violence a court session to expedite on these cases? A case like she's citing here, I'm having goosebumps on this because it's against culture, it's against religion, it's against humanity, and yet they're still coming up.
Maybe just before his worship answers, on a session that we've been having, usually you'll find 40 cases. Out of the 40 cases, his worship will have like about only 10, which will be murder and robbery.
And the rest?
GBV.
Confinement and rape.
Of our 1,800, about 800, maybe 800 to 1,000 could be GBV, but at least 800 are GBV. For one nature or another, rape defilements are very common.
Sure.
So they take 70% of the
do we have a court session dedicated to sexual and gender-based violence for this?
Thank you very much for that question. Because of those challenges that she has cited of what happens to
and they're very glaring.
You know, everyone gets concerned. And we want to appreciate so many partners have realized that this is something that we need to tackle together. We have had several partners coming on board, like she has mentioned, the UN Women. We have IDRO, we have UNICEF, Pepperdine University. So those are a few I can mention of the partners who have seen that we need to tackle this problem jointly. So they have been coming up and giving us some resources to supplement what we get from the government of Uganda in order to handle this problem. So we have been organizing special sessions specifically to address these cases across the country. We have tried to organize them across the country to ensure that we reduce on the number of cases. Like he has mentioned, 1,800, you have almost over 1,000 of that category alone. And of course, most of them involving children. So we have been taking them as a priority to see that we try and make sure these cases are handled expeditiously. Our ideal aim is in the future, like I've talked of the divisions that are specializing, we would want to see a court which is specialized in only these cases. And we put judges there who are only handling these cases. With that, we hope that we can be able to expedite these cases and handle them in time. Yes.
Thank you so much. The worship in Senga, what could be your parting shots as we're finalizing this conversation? You see, when it gets to judiciary, we should have like 3 hours of talk because there is so much the public is not aware of and how the processes rhyme. But these conversations bring it closer. Nsenga, first, what could be your parting shots to the public as we're finalizing this conversation?
My parting shot is that we're doing the biggest challenge judiciary has always had is, maybe someone has hinted on it, is case backlog. Cases taking long. A case becomes backlog when it spends in the system 2 years and above. So of our 1,800 cases, the backlog now stands at 400, approximately 400 cases. So our new approach, we hope to be a game changer. We want backlog to be a thing of the past. We are hoping that by the end of the year we shall clear all our backlog that we have now. And in due course, we want to have real-time hearing of cases. We want someone to be charged in a magistrate court. The moment somebody says we have committed already, we want the judge to be on standby to hear that case. Otherwise, we want to appreciate your time, NTV, Andrew, your time. We want to appreciate our partners, Uganda Police, DPO, DPP, Uganda Prison Services, Uganda Law Society, and the other partners who give us logistical and financial support, whom His Worship has mentioned. Thank you so much. Let's work together. And as you say, the GBV cases involving children are constantly getting
repetitive,
increasing. We have to keep an eye on our children. And in the past, the victims were mainly girls, but now we are also seeing
boys coming through.
Boys coming in. We have special sessions at Nagurumand home, because these juveniles, for them, they should be tried within 3 months. So we give those cases a priority. We are seeing an increasing trend of abuse, sexual abuse against the boy child. So to viewers out there, keep an eye on our children. And the perpetrators will be anyone, relatives, people at home, people who are close, usually are the perpetrators. Keep an eye.
Miss Samari Wakoli, as we're finalizing, what are your parting shots? Because I was the DPP. We appreciate your service and all, but what are your parting shots to your clients?
To my clients who are out there, I want to assure you of the services of the Office of the Director of Public Prosecutions. Right now we have 16 regions across the country, and the regions are headed by Assistant Directors of Public Prosecutions. We also have chief state attorneys who are heading the districts, and they are there to serve the people and the public. In case one has reported a case and they feel that the case is not properly being handled by police, the Constitution gives the mandate to the DPP to direct police carry out investigations. So in case they are having challenges and police are not being responsive, or they feel police is not helping them, let them come to the Office of the Director of Public Prosecutions. We shall be able to help and to support them. If at the district they have not got help, let them go to the region offices. Like I mentioned, we have 16 regions. One in Kampala, we have Nakawa, we have Mbale region, we have Soroti region, we have Lira, we have Gulu, we have Mbarara, we have Kabale, we have Masaka, Greater Masaka, and then we have Mubende, we have Fort Poto. So they can reach in any of those offices and they will be helped. Then also, if they think that the region office has not helped, they can always come to the head office itself. The director has a whole complaints desk office in her office, headed by the head of complaints, who is a very senior officer. They can handle the complaint, and then also other members of the staff who are there can be able to support them. Then secondly, they also need to know that my case is their case, and my case is as good as my witnesses. So for me to prove a case beyond reasonable doubt, I need witnesses. When we have sent process servers and we have told them that they are needed in court, let them take it as serious, that we need them to come to court, and we need their evidence in court, because if they have not testified, court will dismiss this case, and the accused will go back to the village and live his life like as though no offense was committed, yet we still have a victim who is hurting and who is still traumatized. So please come to court and testify, and then also contact us on any of our social media handles. We'll be able to help. Our public relations team is always on standby, and we always do follow-up complaints that we receive. We also receive complaints from our team and to our stakeholders that we work with. So thank you also for your time.
Thank you so much to all the the viewers who have been a part of this. I couldn't read any tweets because of time, but thank you so much for being part of the Criminal Division Stakeholders Engagement. In studios with me, I had His Worship Jameson Kademani, who happens to be the Public Relations Officer to the Judiciary. We have His Worship Festo Nsenga, the Deputy Registrar, Criminal Division, and Ms. Wakoli Samali, the Assistant Director of Public Prosecution. I'm Andrew Chamagero, and this conversation was powered by the Judiciary. Have a lovely afternoon.